All rise. The public hearing of the inquiry under Section 91 of the Consumer Control Act 1982 into the Queensland operations of the Star Entertainment Group Limited is now resumed. Please be seated.
Well, good morning. I have the benefit of the written submissions from each party, and I'd invite now Mr. Horton to speak to his submissions or his side's submissions.
Thank you, Mr. Goddison. As you've indicated, Mr. Goddison, submissions were delivered to you by a councillor assisting in writing on Saturday evening, and as I understand it, you've received this morning early the Star's submissions in effect in response.
Yes, I have.
Mr. Goddison, you will have noted that there were two very useful documents which helped refine the issues but referred to in those submissions. The first was an interim investigation report by OLGR,
Yes.
dated 21 April 2022, which is in volume 6 of Exhibit 3 behind tab 6.1a. And then a response to that report by the Star's solicitors, KWM, about the extent to which matters in it were contradicted or accepted.
Yes.
And that letter provided, I must say, some great assistance in understanding what was in issue and what wasn't.
Yes.
And to some extent, I might take you to both those documents from time to time
Very well.
as a way of indicating that the work that was done before the commencement of public hearings to distill issues and to some extent to afford the Star natural justice about the submissions which might be made in respect of them. We really make one overarching point at the commencement, and that is that we don't yet have the benefit of Mr. Bell's report. The terms of reference do direct the inquiry to pay regard to that report. It's not due to be finished until the 31st of August. And of course, it's to be given to the regulator in that state, but it doesn't mean, of course, on its face, it would be made public. That's a matter for New South Wales.
Yes.
We just point out that we've not, of course, had any regard to any such report, but one needs to. And for that reason, what we've done is left for the moment any overarching submissions we'd seek to make about overall import, overall significance, or any of the larger findings that we invite you to make, because propriety indicates not only should we have the Bell report first, but there might be adverse inferences that arise that should be put to the Star for comment before that progresses very far down the track.
This does leave in limbo that issue, and we can but hope that it's made publicly available.
Yes, that's precisely right.
There's no other way of
No.
that we may obtain it. Yes.
No, and counsel for the Star correctly accept that the submissions being made here are already stage one of the submissions. We've tried to do with as much as we can.
Yes.
That's been possible because of the investigative work in the report. It's been possible because of Star's response, and it's been possible because we've been able to distill in the course of the public hearings and in submissions those issues where there's no serious contest and those issues where there are, and if there is an issue, exactly what the issue is.
Yes.
Can we start, please? We'll try to address this issue by issue. The first is China Union Pay. This is one specific direction in the terms of reference to examine the use of China Union Pay debit or credit card facilities. Now, that was done. It was done orally, but we've also included in the tender bundle for you, Mr. Goddison, from the outset, volume 5 of Exhibit 3, the core documents that bear upon this issue. And if I could just ask you to be shown where they
Yes.
are and one of those documents in particular, they're behind tab 5.2 of volume 5, exhibit 3.
Yes,
So those tabs really running from 5.2 through to tab 5.9 are what council assisting says are the key exchanges that occurred about this issue. And we draw your attention in particular to an email of, try to find it, November 5.5. In the middle of the page, the paragraph beginning, as previously mentioned.
yes, I have it.
That's the core of the issue.
Yes, the comprehensiveness of that.
Yes, that's
issue.
it. And that's right. So in effect misleads by omission. That is, it seems to suggest it's about entertainment and accommodation when in reality, as Mr. Hogg candidly accepted, the funds really were generally used for gambling. The central facts, it seems, are not seriously in contention. We've set them out in broad summary at paragraph 10 of our written submissions. And then the issue we framed in paragraph 13. And it comes down to this. There was an understanding by staff members that there was a prohibition on using these cards for
Well,
gambling.
by certain staff members, not
Certainly,
all.
certainly,
Obviously.
but not only junior ones is the point.
Yeah.
But that's exactly right. It wasn't, we don't say it was uniform. Now this issue and these facts were the subject of submissions by Star in the Bell inquiry. We asked whether Star made the same submissions here as they did in New South Wales about the core issue, and the answer is yes. And could we hand up to you 3 documents which record what those submissions were? And just for reference, they're supplementary submissions made by, thank you, Star, Part O, Alpha O, submissions made by the Star section D.7, and a transcript of day 41 in the Bell inquiry, a publicly available transcript, pages 4194 to 4195.
Very well. We'll receive these.
Thank you. And the relevant part on 4194 of the transcript there, Mr. Goddison, is at line 40 and following. Obscured the true nature of the transactions and masked the fact that funds were used for the purpose of gaming from Union Pay and Chinese financial institutions. And it runs over the page to line 34.
Yes.
So there were acceptances by the Star in our respectful submission properly made. And now respectful submission properly applicable in Queensland, subject to some other relevant circumstances which we'll come to.
Yes.
Now, one relevant circumstance is this, that in Queensland, the total value of CUP transactions at the Stars properties in this state was $55,434,525. Sorry, 55,435,000.
425.
Sorry, $434,525,
Yes.
which is not as big as was the case of the New South Wales total transactions of just over 449 million. That's a relevant factor. I don't need to take you to it, but for reference, the Star, through its solicitors, have proposed and accepted, I guess, these figures at paragraph 1.3 of the response to the inter-investigation report, which is a tab 6.1E, volume 6 of Exhibit 3. Said in that response also, given the passage of time, the Star's unable to confirm with precision when the Star and each casino operator became aware of the CUP scheme rules, which really accords with a point you made earlier, Mr. Gotterson. I'd seek to tender that bundle of documents, those 3 documents, really as Exhibit 5.
Very well.
Gotterson.
These will be received, 3 documents as Exhibit 5.
Yes. Now, the essence of the problem, we say, is that the understanding of certain staff members that they held, the conduct they engaged in, to be understood in light of that understanding. So it's not so much about whether one can point to a Chinese law or a meticulous analysis of the agreements. It's based upon an understanding of people who, at the relevant time.
Yes.
We would submit the findings we would invite you to make are the same as those which are in Exhibit 5. And particularly in the transcript of 4194 to 4195. Bearing in mind the smaller, still large, smaller amount involved in the affected transactions than in New South Wales.
Yes.
The other issue that arises uniquely in Queensland with respect to China Union Pay is the dealings between Star and the regulator concerning amendments to the ICMs. You might recall in 2015 they were amended to refer to the possibility,
Yes.
the authorisation to use
China Union Pay.
Yes.
Yes.
And then later in 2016 removed to simply refer to debit card usage. The 2015 approved version of the ICMs are in the volume concerning China Union Pay, Exhibit 3, Volume 5, behind tab 5.10. I don't need to take you there, but that's the reference. And then in volume 6 of Exhibit 3 of the ICMs as they were finally approved to refer to debit card transactions. As you pointed out in the course of our opening and in evidence, the Act relevantly permitted the use of debit cards from before any difficulty existed with respect to China Union Pay. That is, the Act was amended in 2016 expressly to refer to debit card usage. And on one view, the Act did not prohibit it before then in any event, but the amendment made it clear that debit card was able to be used for gambling in Queensland. Now, we don't suggest there's any deliberate conduct in the way in which STAR dealt with the regulator in terms of being less than complete. We say, though, and Mr. Hogg accepted, it would have been preferable for the STAR to have told the regulator more. And this goes, we say, to transparency and insufficiency of transparency with the regulator. Should have given fuller information to the OLGR about those arrangements, which underpin the changes and the reasons for them. That's really a point of candour.
Well, I think those who were dealing directly with the OLGR themselves didn't know, so it's more a systemic failure, would you say?
Yes.
That they didn't know.
Yes.
And didn't therefore inform.
Yes, at the points that needed to be raised up to be fully considered with the OLGR didn't seem to make it that far. In effect, the context of the amendment. And the STAR, for example, says at paragraph 15, subparagraph B of its written submissions on page 4, there's no suggestion that those within the STAR who understood that CUP funds were not to be used for gambling communicated that understanding to those in Queensland who are responsible for communicating with OLGR about the ICM changes. And that's correct, there is no suggestion of that. But we turn next to exclusions. Again, this issue was the subject of the inter-investigation report and a response from KWM on behalf of the STAR of 22 August 2022. The issues in respect of this topic are very clear, and as we understand it, there's no substantial disagreement about its fundamentals. In the KWM letter, 6.1E, volume 6 of Exhibit 3, from page 3, section 2, it deals with the exclusion policy.
I've just got the letter now. It's
yes,
to
page 3, section 2, exclusion policy.
Oh, yes. Yes.
And there's an explanation here of what occurred on pages 4 and 5. But none of that, in our respectful submission, takes away from the fundamental facts that the issue by Interstate Police Commissioner always justified the issue of a withdrawal of licence unless there was overwhelming contrary reason not to mirror it with a WOL. Second, that in truth, the WOL was always something which could lawfully have been issued in response to such an interstate direction. Third, that where the exclusion was by the New South Wales Police Commissioner in respect of the STAR New South Wales there can be no reason why the Queensland property could not have claimed to know about it. Fourth, that it's not until 2019 that the STAR's policies change to require a mirroring. Fifth, that even when that occurs, the mirroring wasn't dealt with retrospectively. And next, even when it was eventually applied retrospectively, that project wasn't completed until May 2002. That in any view is a very, very long time for exclusions which should have happened long before. Mike, we deal with 2 points that the STAR raises in response. The first is that the number of people who might have been caught by the need for exclusion was smaller than one might think. I'm just having a trouble for the moment to find the exact numbers. I've circled them somewhere. Was this that there were not many hundreds of people excluded by the Police Commissioner of New South Wales. So the people to whom that would apply anyway were relatively small. The point we would make in response is, well, the people who've behaved in a way sufficient to attract the Commissioner's direction are ones which have warranted that. And second, they're ones who, because of that, and because of the underlying facts, no doubt, upon which the directions made, are people who definitely should not be in a casino, there or here. And that the real problem with this problem is that it goes to the heart of what one would wish from and expect from casinos, that is, that they not act in a way and positively act to protect themselves from infiltration from criminal elements or activity. And not excluding by WIL brought about that very risk.
I think the original version 2.1 didn't contemplate a WOL as a means of exclusion and was limited to exclusion orders.
Yes.
And under the Act.
Yes. And so what Mr. Hogg said about advice he'd received internally seems to be right as a matter of fact that he received that advice.
Oh, yes.
We just contend the advice was just clearly wrong.
Or the 2.1 deficient in that regard.
Yes, entirely. And not, I think its replacement was 6.1 of the 2019 policy, which then states the mirroring requirement. But even then, there seems to be a reluctance or a misunderstanding in the sense that anyone from that point on excluded by a police commissioner would be as much a person you didn't want as a person who, in respect of whom a direction still subsisted, albeit from the past. Now, the STAR resists some of the submissions we make about this. Paragraph 31 of Council's written submissions, they would say there shouldn't be a finding. You'll see there in 31A.
Oh, yes.
There should not be a finding there was an active disregard for the law and for the underlying rationale of police commissioner exclusions. And then they suggest a finding that's more appropriate, that being incorrect. You'll see there in the third line of subparagraph C.
Yes.
We respectfully submit this, that incorrect is only a matter of fact. The significance of the incorrectness is what we've submitted. That is one thing to be incorrect, but incorrect in a matter which was of so much import, and which even once corrected with 6.1's replacement of clause 2.1 of the policies remain unactioned for those for whom directions subsisted, and hence the active disregard. Thank you. The numbers concerned, the Star points out in its response to the interim investigation report at page 4, is that there were 768 persons the subject of a New South Wales police exclusion, but so far as Star's records are concerned, 36 persons only of those attended one or both of the Queensland casinos at Star in the past 9 years, and 15 in the past 5 years. And of 36 persons, 8 were excluded prior to or around the date of the New South Wales exclusion. All have now been excluded. So they would make the point, no doubt, I know friend Will, that when one looks at this problem, one sees it in light of numbers as well. Thank you.
Yes.
Points made at paragraph 32 of our learned friend submissions about Victoria, that is, a police commissioner direction in Victoria might not come, as we understand it, is the submission to the attention of the Star, as would one in New South Wales. That is, the one in New South Wales would be in respect of, in those days anyway, the New South Wales Star Casino. So one couldn't say that wasn't within the knowledge of the group. Whereas in Victoria, one should bear in mind the exclusion would be from a casino that was not a Star Casino.
Yes.
And there's no automatic way in which that would come to knowledge.
Mm.
And you might recall that persons 1 and persons 5 of our case studies were excluded in New South Wales, and person 2 was excluded in both New South Wales and Victoria. There are our submissions on that topic. We say the errors placed in serious jeopardy the integrity of Queensland casino operations.
Do you have any submissions in regard to their paragraph 31A?
Yes. The view, I think, expressed by Mr. Hogg, I probably won't put this as accurately, I'm sorry, as I should if I'd had the transcript in front of me, was that it was Star's mind was turned to the issue as he understood it about what should be done. Certainly his mind was, he says. And it was thought that the, in effect, the police commissioner direction was just that, without attentiveness in our submission to the fact that a public official, senior public official making a serious order would necessarily be understood to have done so on, one, information that was sufficiently probative to make this, the serious order, but B, that person would likely have available to them intel, as it said, not just information that would be available from newspapers and publicly available. The nature of that office holder is that they would have access to the New South Wales police system and be advised by less senior officials. So it would reasonably assume from the outside that that person would have had acted authoritatively, and second, on probative information not all publicly available. And just for reference, it's in the transcript at page 240 at about line 17 where he's asked that question.
Very well. Thank you.
Next, can we turn to the question of briefly junkets? It's not in dispute that the junket business for the time being ceased in Queensland. That decision was made in October 2020 on Mr. Hogg's evidence, as we say at paragraph 58 of our written submissions. The group has no intention of junket groups returning to its casinos. That's a function we suggest from the outside at least that properly recognises the particular inherent risks of junkets. The more remote dealings one has, the less visibility the casino has over the persons with whom it's dealing and the destination and source of funds. The Star has, I think it's fair to say, preserved its position in the future with respect to sole participant junkets on the basis that, one, in respect of such junkets, the risks that attend them are lower than for groups, because one deals directly with the person who is the gambler, and in the event says it would only do so after satisfying the regulator that there's relevant sufficient internal controls. That really leads to the next topic, which is the Star's commitment to its anti-money laundering responsibilities. Star emphasises in its submissions that the term of reference is directed to commitment. And correct linguistically and probably in substance to distinguish that from adequacy, although adequacy is, we say, in play with commitment because it's a demonstration of how committed it is to have brought its system to be up to an adequate standard. First, this issue is a group one, so we'll be very much affected and informed by Mr. Bell's findings, if any, on the topic. And we understand it was the subject of considerable evidence and submissions there. We invite a submission, which I understand is not resisted, subject to limitations on time, that at the time that KPMG does its review in May 2018, the Star's AML processes were seriously deficient. Star accepts that at page 37 of its written outline. But it says that that's as at the date of the KPMG reports. I'm sorry, I might have said page, but I mean paragraph 37. Now, not only is there the KPMG report about that, which we say is critical of the program, but you have the benefit, Mr. Goddison, of case studies 1, 2, 3, 4, 5. 1, 2, 3 in particular speak for themselves as clear, practical, concrete cases that the Star's AML program fell far short of what ought to have been, seriously deficient. We've said it in 71, the evidence of Mr. Hogg and Mr. Steiner, which in effect, which accept that, including that these non-compliances would expose the Star to risks, including involvement in the criminality of others and money laundering. Really comes to the question, and there's no doubt that through Mr. Steiner in particular, that the Star is seeking to use his word, uplift
Yes.
that program, and has come some considerable way to whatever the relevant standard at the end should be.
Yes.
And Mr. Steiner's evidence, I think, it's fair to say, is that he is satisfied at present it is compliant with legal obligations.
Yes. A core, I think core.
Yes.
Compliant, in core respects.
Yes. And since the Bell inquiry, only in very recent times, we made reference to in our written submissions, a report has been prepared by a company called RSM,
Yes.
Maturity Evaluation Status Report, which I'd seek to tender for the record. I don't need to take you to it, Mr. Goddison, but it updates where things are presently at. If it was referred to, including reports of McGrath-Nicol. I might tender that in due course. I'm just giving my little friend a look.
Oh, you just, yeah, I see. Right. Very good. That's the RSM report.
RSM report, McGrath-Nicol report.
Yes. Was that, it's actually been finalised, the
It has.
RSM report? Oh,
Yes, and the
I see.
RSM report only on the 29th of July 2022 is the date.
Oh,
So, Mr. Goddison, we'd asked you to summons the production of it late last week,
yes, that's, I
and
remember
the Star
that.
very properly suggested to us late last week that it had been finalised.
Well, the picture, nevertheless, is one of, at least since 2018, attention to this issue, though the attainment of a satisfactory situation has taken some time.
Yes, taken some time, but certainly attainment of a situation which, on its face, one's yet to see the culture lived out, which on its face seems satisfactory.
Yes.
There's some respects in which we're going to express some reservations about that, but yes. And Mr. Steiner, we've said, we suggest respectfully, presented not only as a reliable witness, but as someone with the necessary background and skills to do what he's been tasked to do. That volume I've handed up might have been made part of Exhibit 3. It's volume 10.
Yes, tender bundle 10 will become part of Exhibit 3.
Thank you.
Need I keep it in front of me?
No,
or?
no, it's really so your record's complete now.
I have it.
There's
Thank
two
you.
respects in which we express concerns. One is that point upon which Mr. Steiner was examined, that is that the high risk in this casino translates on the casino's view of the world to a medium risk for Austrac.
Yes.
There's a bit said about this in the submissions, and Alan and a friend will take you to it. In the end, it's this: high just means high. Like beyond reasonable doubt just means beyond reasonable doubt. And if one seeks to perform tricks in respect of a label which is otherwise simple, then that is fraught with error. That is, despite the fact that you think the risk is high, don't worry, because Austrac, on our interpretation, not Austrac's interpretation, would regard this as medium. And it's just not justified. And I think Mr. Steiner properly accepted
Yes,
that
he
it should be changed.
Speaks of a need
Yes.
to align the terminology
Yes.
in that regard. Though
Yes.
I think he said as a matter of practice, what is regarded as high under stars would be regarded as high for
He did say that.
yes, Austrac purposes.
Yes, he did say that.
But of course, your point is that not everyone has Mr. Steiner's knowledge, and those who see the word medium might be deterred from referring to Austrac.
Yes, and in fact doing the other thing that's necessary, which is do the source of money inquiry.
Yes.
So it's a relevant to the AUSTRAC referral, section 41, but more importantly, perhaps just for present purposes, focus on the star zone risk. Under 36, it's the trigger by reference to the standard in 15.91 of the rules in the AML. So the trigger is just when it's high, you've got to do these things. Whereas if I've assessed internally in the star and I'm not Mr. Steiner, a person was high, I might look up this table and go, oh, it's okay because I don't have to do a source of money inquiry, because really, by virtue of the table, which frankly is just a table, I can demote my assessment of high to medium and magically transfer it. So that's the first problem. The second is a related one. It's yet to be seen whether this culture and the way in which this works is actually that proper source of money investigations are done, not only when people are at high risk, properly high risk, substantively high risk, but when, as Mr. Steiner said, there might be other occasions when it should be done, large amounts of money, suspicious circumstances, and so forth. But it does seem, and I think the Star candidly accepts, that the chronology, at least, exposes deficiencies in assessing the source of wealth or source of funds with respect to particular individuals. Says it's largely historical. They say that at paragraph 54 on page 13 of their submissions. Now then, at paragraph 80 and following of our submissions, we take up the issue of Mr. Peasley. As we understand it, on the Star's written submissions, paragraph 56 and following at page 14, corrected by our learned friend if I'm wrong, does seem to accept that what was done was pursuit.
Yes. Well, but certainly that was a substantial aspect of it.
And of course, if any more were needed, the activation and deactivation of the card to allow things to happen in addition to the benefits was, all barriers were cleared. And then at paragraph 60 is accepted, frankly, quite properly in our very respectful submission. But some of the language we saw used in the emails was unfortunate or distasteful. We put it slightly higher. We say it shows one-eyed focus on profits and money. We said that at paragraph 84B. And the Star resists that.
Yes.
We move to gambling harm or safer gambling. The terms of reference direct attention to the approach to gambling harm minimisation, fitness for purpose, implementation, resourcing. But we know from other inquiries and indeed from the nature of the topic, which engages policy, that it feeds very much into what you also might consider, Mr. Goddison, as part of the Part C.
Part C, yes.
And for that reason, we said in our submissions we didn't expect, because we haven't foreshadowed all of it, the Star would answer all of it or commit anyway, and there's no criticism made of that. But we'd simply point out that we would, in very recent times, the first issue is carded play, carded versus uncarded play. Mr. Hogg gave evidence about that. Paragraph 100, we've extracted what he said. In effect, that one needs to be mindful of it being on a
industry-wide, you might say, basis.
yes.
Well, there's good sense in that, isn't there?
There seems to be, and in New South Wales, in the Casino Legislation Amendment Bill, passed by both houses, I'm not sure it's received royal assent yet, but certainly passed by about houses. Section 71, capital A, says it's a condition of a casino license that all gambling conducted at the casino must be by use of a player card issued to each patron that complies with certain things. We just want to draw that to your attention as a recent initiative in New South Wales on this topic, where carded play has been made mandatory. Now, again, it's across the board for casinos, it seems. But the details yet to come, obviously, in requirements prescribed by regulations and other requirements in the ICMs.
Well, it could be certainly player confusion if they gambled at casinos in New South Wales and come to Queensland and confronted with a situation whereas down there they must use a card. Here they're looking to how to use their card, and then they're told no, you don't have to.
Yes. Yes. So Mr. Hogg's point is, well, if you want information about that, you need the full information. You might miss someone, or you might wrongly think someone's got a problem from a carded play that's skewed by reference to its small scope.
Yes.
There's the question of preset limits for electronic gaming machines. Mr. Finkelstein gave consideration to this and related questions in his report in Victoria concerning Crown Casino. We've given you an extract from that report, relevantly, Chapter 8, and that's behind, I don't need to take you to it, Exhibit 3, Volume 2, Tab 2.7.
As with carded play, these seem to be matters that are Part C.
Yes,
Rather than
they do. And for, yes, and for that reason, I won't take up too much time here, other than where it was referred to in the evidence. The next is facial recognition technology, which we submitted respectfully.
I think it's common ground that it's desirable to a point where it's almost there at the Gold Coast.
Yes, that's right. And the question is, ultimate question, in terms of item 5 in Part A of the terms of reference, what we would say, is the STAR's approach to gambling harm minimisation adequate? Well, the program is in the course of improvement. Mr. Taliaferro's evidence was to the effect. There were many areas where he said things are being looked into and developed. He said it's sufficiently well resourced.
I think you had made a reference to there being 4 of the additional 25 in Queensland, and Mr. Beecham, his submissions says it's 10 of 25. Do you accept?
Can I just?
Have I got that correct, Mr. Beecham?
I'm sorry. Could you repeat what?
Oh yes. Now I've got to go and find it. Oh yes, your paragraph 80.
Yes, we say there's 10 of the 25 in Queensland, but remembering that the 25 are dealing with the time play management system.
Oh, I see.
So
yes.
So there's 25 new people that, to deal with the time play management, which is, as you might recall, that's the system that's largely associated with carded gaming.
Yes, yes.
And yes, so 25 people on that, 10 in Queensland.
Oh, very well. So there may be a little bit of cross purposes.
Yes, we don't disagree with what's just been said by Mr. Beecham.
Right, very well. Thank you. And so that would mean in your paragraph, where is it?
126.
No, 26 and that,
127.
and should that be amended to 10?
Yes, with the located here might be the difference, but
Oh, I see.
that we might, not that location may not matter, but
Yeah.
physical location.
Well,
We might we might seek to clarify that.
If that could be
Yes,
clarified,
yes.
yes.
So really the point is this, that at the moment, the measure of the adequacy of the RSG program is in the context of what the regime is.
Yeah.
And our submission is, well, there's justification for the regime to be different and enhanced, which might change, of course, the measure of the adequacy of the system itself, but that's a Part C question. That is, the benchmark against which it's to be measured might change in a regulatory sense, in terms of what recommendations you might make under Part C, Mr. Goddison. Mr. Goddison, there the key matters which have arisen on stage 1. And unless it's any further questions, they're what we propose to submit to you about.
Thank you, and I'd invite Mr. Beecham now to address.
Thank you, Mr. Godson. So in our submissions delivered to you this morning, we've tried to do.
May I ask you one thing I should have before you start? Some of it has blue type,
Yes.
which I'm told is confidential. Other, I think there's at least one
Purple.
which is purple type, which is
You don't
said to
need to
be
worry about
privileged. Is that simply for my information, but not a restraint upon embodying it in the report?
The purple you don't need to worry about. We've now resolved that so that you can treat that as black,
Oh,
if I can put it that
now,
way.
yes, very well.
The blue was really just, it was done during the course of preparing the submissions so that those parts were there for the purpose of identifying matters that may raise an issue about being publicly available. But of course, we're open to discussing those things with counsel assisting further if that creates a difficulty.
All right. Is it, yes, there are a number of blue. There is, just I should clarify this. Page 12 best illustrates it. There is in light blue, paragraph 49, for example, yet immediately above, in paragraph 48, there's something in dark blue.
I think they're all intended to be blue. Perhaps that's
All
just
intended to be blue.
that's some facet of the word processing.
Yes, very well. I understand. Thanks.
Thank you. So in delivering these submissions, we've tried to go through counsel assisting submissions as responsively as we can, with a view to identifying really 3 things to try to assist you in your report. The first is areas that are not in dispute and that we accept, which would obviously allow the findings more easily to be made. The second is the opposite, areas of disagreement on which there will then need to be some determination as to what findings should be made. And thirdly, areas that we independently emphasise for the information of the review. And there's a couple that I'll emphasise in our oral submissions today.
Very well.
The first topic that my learned friend dealt with was China Union Pay. And that topic we can deal with, we think, by saying these couple of things. The first is that, as I think Mr. Horton pointed out, we don't resist the proposition that you could make findings here in accordance with the concessions that were made before Mr. Bell in the New South Wales inquiry. And we point that out at paragraph 11. We do point out that Mr. Bell will eventually deliver a report which presumably, we can say no more than that, will take those concessions into account. And so we point that out solely for the purpose of perhaps identifying that there's potentially work there that might not need to be done by this review because it might come from Mr. Bell and be done.
Yes.
In terms of the Queensland specific issues, I think are agreed with Mr. Horton as to the figures, the amounts that were transacted in Queensland as compared with New South Wales, substantially less here in Queensland. And secondly, and this is paragraph 15, we point out, and I think we understood some level of acceptance here, that in terms of the issue, the Queensland specific issue that was raised about the submission of the ICMs, the internal control manuals, to the Queensland regulator and the dealings with the Queensland regulator, that we accept, of course, what Mr. Hogg said, that in the interests of greater candour, the Star should have given more fuller, more complete information to the regulator about the arrangements underpinning the changes to the ICMs and the reasons for them. And Mr. Goddison, you might recall that the change that occurs is that there's initially a reference to China Union Pay
Yes.
in the ICM.
In 2015.
Correct. And then it's removed, but it's removed partly at, well, it's removed at a time when the change comes into effect.
The legislative change.
Debit cards to be used.
Yes.
So suddenly.
So I picked that up.
Thank you. So we submit that it's to be, well, it may be inferred that the shortcomings in the level of information provided to the regulator that Mr. Hogg referred to were a consequence of the fact that Queensland staff who were responsible for communicating with the regulator were unaware of any particular significance that further information might have. In terms
Yes, I don't think the evidence really impugns or would permit findings impugning the conduct of the Queensland resident staff who communicated directly with the OGR, but it rather being a systemic failure of them not being informed of the truth of it.
Yes. That moves us on to the second topic, exclusions. Now, we've said in our submissions, and this is one of the areas where we do look to emphasise some things independently on this topic, that the failings in relation to exclusions, going back in person one's case, for example, to 2007, we of course accept, Mr. Hogg accepted them in evidence, Mr. Steiner accepted in evidence that these people ought to have been excluded at a much earlier time. But we say it's important to understand why that happened, because that allows a proper characterisation and also then a more confident conclusion, one which we'd urge, that these things will not happen again under the current scheme or policy and the current leadership. We take the review back to Mr. Hogg's evidence where he described, having looked into it, his understanding of the past approach to exclusions. And he explained, and this is paragraph 17 of the submissions, in his statutory declaration, that prior to 2011, the issuing of WOLs, as we've affectionately referred to them, withdrawals of licence, was uncommon, become more common it has become more common over time, and certainly in recent times has become the tool of choice, if I can put it that way. So that was the first point. And the second was that the understanding within STAR at the time was that to exclude somebody, and really this at the time didn't distinguish between WOLs and exclusions, was that there needed to be a sufficient evidentiary basis for excluding a patron, and that unproven or unsubstantiated allegations were not a sufficient basis for excluding a patron. So they needed something to rest their decision on. Now, Mr. Hogg, in dealing with person one, then sets out in his evidence, this is summarised in paragraph 18, what he did when he realised that person one was gambling at the Gold Coast and was the subject of a New South Wales police exclusion. And I won't take Your Honour through that, but it's fair to say that Mr. Hogg was, in our respectful submission, proactive. He found out about it, he asked about what had been done, he received an explanation, he challenged it, and he went further and looked for a way in which he could improve the situation in terms of person one's continued participation. So we say there's 3 points. The first is that, starting at paragraph 20, the way in which a police exclusion from another state was dealt with in that historical time, and that's really 2007 to 2019 when the new exclusions policy came in, was influenced by two things. First, as I mentioned, the view that the Star needed to have a basis to exclude somebody and needed to justify it by some level of evidence. And the distinction between exclusions and WALs just wasn't made at the time. That didn't have what there was something in that we put to one side the failure to separately consider a WAL for the moment because it wasn't being separately considered, because of course statutory exclusions might well have been challengeable, and we point out some reasons for that conclusion in paragraph 22. But nevertheless, there was the WAL that might have been availed of.
Yes, I think your paragraph 23 concedes that, yes.
Historically, that's what was understood. Now we look at it and we accept that it was incorrect. The second point, 24, was an understanding, it seems based on legal advice at the time, that one could not use, and we emphasise the word use, the New South Wales exclusion to justify Queensland exclusion. And that, in our submission, is the critical issue, that the failure to immediately exclude somebody in Queensland was not based on some perception that the New South Wales Police Commissioner, that there might have been better information around, but on the fact that that piece, if we were lawyers, we'd say that piece of evidence wasn't available or admissible, we'd say in court, to use in Queensland to justify the exclusion. So we knew, the Star knew, but it had to go and try to find some other evidence to justify its exclusion because it couldn't use the New South Wales exclusion. Now, once...
Well, that's all very difficult, I must say, to accept as an accurate legal or summation of the situation legally. Of course, it's not.
And of course,
right.
now, in the 2019 policy, it is used.
Yes.
So in terms of the correctness at the time, again, historically, probably not correct. Fixed up now in the sense that the 2019 policy mirrors, I think the word has been used, the exclusion, and is universally acknowledged by the Star's witnesses as being a much better policy.
Yes.
But the point we simply make, Mr. Gottison, is that it goes then to some of the submissions that we urge you to reject, and my learned friend referred to some of them about, and we'll come to them in a moment,
yes.
if I can, that understanding the reasoning at the time in this way is not so much a matter of saying that it was correct or that it was justifiable, because we've changed, the Star has changed and has improved its approach, but is to say that it is simply that. And I think my learned friend, Mr. Horton, referred to that the Star's submission to you is that the correct characterisation of those decisions was that they were wrong, but no more. They reflected a logical but wrong way of approaching things. Sorry. They reflected a wrong way of approaching things that can be understood to be wrong now, but that in terms of, for example, a finding that the approach was based on thinking, and this is paragraph 31.
Yours?
Yes.
Yes.
So this is where we deal with some of those findings, thinking that more or better information would be publicly available than available to a police commissioner. We say no, that wasn't what happened at the time, and that doesn't accord with the evidence.
Well, I think that's probably taken from the drafting of 2.1, which I can readily. Somewhere.
33 of council assisting submissions.
What paragraph? Sorry, I missed it.
33.
33. I knew it was here somewhere. Yes. um, upon the issuance interstate, investigation will assess readily available public information.
That's right. So when one thinks about that in the context of what I've just said,
Yeah.
it conforms with that in the sense that it's based on an understanding that the exclusion isn't available to be used. It can't be used, we emphasise. So it triggers the search for something else that can be held up and said, that's the basis for excluding this person.
Well, that's the point. It confines the investigator to readily available public information, doesn't impose any duty to go and search out that available or search out relevant public information. It's almost as if to say whatever flops on the desk as being readily available. No inquiry, as I say, needed. And an investigation to confine itself to that and not to have regard to the interstate exclusion itself. There seem to me in the 2.1 just glaring deficiencies, I have to say.
Obviously not an acceptable policy because it's been changed now to a much more appropriate
Yes,
policy, as Mr. Hogg
yes.
and Mr. Steiner effectively accepted. But the point I suppose we'd make is two things. The words readily available may not be the greatest way of expressing it, but we would...
No, well, it means whatever just happens to come within eyesight.
Well, we would suggest that, in fact, readily available simply it acknowledges the fact that the Star doesn't have any compulsory way of obtaining the information. It can't go out and issue subpoenas.
Of course not. No.
What it can, anything, I mean, another way of saying it, my words, not policies, obviously, might be whatever it can find to see if it can justify the exclusion. So
that's certainly one way of looking at it. But,
and the point we simply make is that it should not, in our respectful submission, be taken further and suggest that, well, sorry, the failure to exclude should not be taken any further and suggest, for example, some diminishing of the significance of the exclusion as opposed to an incorrect legal understanding that it could not be used and something else had to be found as well, nor a disregard for the law, an incorrect legal understanding that has been fixed up now.
But I suppose in historic, it now is a matter of history and explains things, but it's been at least supplanted since 2019.
That's so.
Yes.
That takes us on to junkets, really just to say that it seems that we are largely in agreement with what Council Assisting says in relation to junkets, and as Mr. Horton identified, the junket play has been suspended, and Star's made certain public pronouncements about what its intentions may or may not be going forward. And those
even with the single, even with the single person junkets.
They're all suspended at the moment.
They're all suspended.
Correct.
But insofar as there's a potentiality of reviving that, it's limited to single player junkets, and not to happen until there's some tick from the OLGR, to put it colloquially.
Quite so.
Yes, understood.
We then move on to the AML topic. We accept at paragraph 37, as Mr. Horton quite rightly pointed out, finding that it's open to find that the AML was seriously deficient at the date of the KPMG reports. We do emphasise, though, what follows in our submissions 38 and onwards, that firstly, the Star took KPMG's findings seriously. The board endorsed a plan. The board oversaw the program of work. There's a mountain of paper that shows the work that was done. And most importantly, that by May 2021, in paragraph 39, Star had engaged BDO to conduct an independent review, and it had found that the program was effective. We've set out, summarised some of the things that BDO said, and in addition, in its phase 2 report in paragraph 41.
Now, is there still caution in anything that is done by way of report concerning Part A, that what's in blue not be repeated? I'm still just not sure.
The AML particularly does raise a concern. As I've said, we're certainly happy to engage with council assisting if the blue parts create a problem for example, the reporting. I think specifically for AML, the concern is more about not making publicly available the content of the policies, because of course, if the content of the policies is made available, then it might give some assistance to people who are looking to avoid them.
Oh, I see.
And so the AML policies particularly raise that issue. Responsible gaming perhaps to some extent do, but it's the AML policies where one is dealing with people who might well try to find a way to get around it.
Very well.
So that's the specific issue. But
well, thanks for explaining that. I didn't quite get the.
And so to the extent that perhaps some things may be able to be backed out of the blue, if I can put it that way, then we're certainly happy to do that if it assists. So the point we make in 42 is that BDO's conclusions particularly are significant because they show that Star has taken significant steps to address the KPMG issues, if I can call them that, and found that it has implemented and complies with a system that complies with the AML rules. Mr. Steiner said that and paragraphs 80 and 81 of his statement, that he considered that the KPMG report issues had been addressed, and Your Honour has the report of RSM, which is now, we would characterise that report as something that has been engaged in an attempt to provide a pathway for growth from compliance to best practice, industry-leading practice.
I don't envisage, but does the same, I'm not necessarily quoting from it, but does the same concern relate to its report?
I doubt it.
Very well.
I doubt it. As I've said, it's primarily the content of the policies and the way that they operate.
Yeah.
So to the extent the report narrates the policies, obviously that creates an issue, but to the extent that the report narrates more consultant language about things. So that's why in paragraph 43 we do take issue with the submission about the Star's commitment to its AML responsibilities. We make that distinction simply, and it may not matter all that much, but the distinction between commitment, attitude, so to speak, and effectiveness, which is a different thing. We accept the effectiveness was no good in 2018, but in our respectful submission, the commitment.
And until very recent times, that's undefined. So I'm not sure whether that was meant until the BSM, the RSM report was obtained, or it may well be 2018 with the KPMG. But in any event, I understand what you're submitting.
In terms of the what we might call the issue of taxonomy that was raised about the risk ratings in the policy and AUSTRAC, we don't want to overstate, or we submit it shouldn't be overstated, partly because Mr. Steiner says that he's looking at doing whatever is necessary to ensure that that is no longer an issue. But we simply make this point, it's not it's not a matter of tricks, as a learned friend said. It is really a matter of taxonomy in the policy, but more specifically that it is the policy, that is the STARS policy, that is the thing that is effective to trigger the steps that need to be taken. So to put it another way, if somebody is high in the policy, according to the policy, that is the thing that causes the steps like enhanced customer due diligence to be taken. There's no cause for a person in the AML department to go back to AUSTRAC and inquire as to what the AUSTRAC rules say about these things, because the AUSTRAC rules exist to inform what should be in the policy. The policy conforms with the AUSTRAC rules, and the policy then dictates what the STARS people do. So in that sense, that is why we make the submission, particularly at 53, that if anything, it leads it to be more cautious in its assessment of individuals because they are rated high, and the rating is high triggers certain things to be done. As I've said, it's something that's under review. So there's reason to think that perhaps the debate is something that will no longer have any significance going forward.
Well, I think Mr. Steiner said there would be
Yes, he did.
an alignment. That might have even been done by now.
I wouldn't, perhaps not by now, but
Yeah.
certainly he said when he was in the witness box, I think he said it was underway, or there was a process underway. I think something to that effect, so that and we would also emphasise that in terms of the present situation, putting to one side the debate about taxonomy and language, that Mr. Steiner, who is an expert, did emphasise that he did not think there was a conceptual difference between high and AUSTRAC's high, and effectively said that practically it would not make a difference in terms of how the people were assessed.
Yes.
So there's some comfort there.
Well, there would be a great high degree of comfort if Mr. Steiner himself was attending to all of these, but of course there are others who work for him, under him, who mightn't have quite the same degree of comprehension.
Quite so. But on the other hand, Mr. Steiner, in our submission, presented as a very professional, cautious man, somebody who would truck no.
Well, I do agree with that.
Therefore, to the extent that he says that, it might be based on an assurance that his policies are tight enough and his team is well trained enough to get that right. Could I move on then to safer gambling, please? This is another area where we do emphasise something independently, because in our submission it's important in terms of understanding and assessing the STAR's responsible gambling policy. So the policy that STAR has now involves a number of layers, as we put it. This is paragraph 62, each of which complements the others in that it will identify responsible gambling issues that the others may not. And could I please outline just briefly what each of those are?
Yes.
The first is that the system involves a whole of company approach. Mr. Toliafoa gave evidence that every employee, 100% of the employees, are trained in responsible gambling, and they're required to refresh their training every 2 years. In addition, there are staff from other teams, that is not from the responsible gambling team, for example, the gaming team, who have specialised training, so training above and beyond what 100% of the staff get. And they fill a role as guest support advocates, GSAs. It's substantial training. We saw in evidence the PowerPoint presentation that's used. I think Mr. Toliafoa said it goes for quite a number of hours. And so they then fill a role as an extra level of trained support for the responsible gambling policy. Now, the rationale of this is that the employees are able to understand and report on responsible gambling issues, that it's a shared responsibility, that it's on everybody's mind every time they're working in the casino, and that it's second nature to them, part of what they do at the casino, not separate to what they do. Mr. Hogg gave some evidence about that and about wanting everybody in the Star to be focused on providing or supplying gambling services safely. In addition, we'd emphasise this about the whole of company approach, that what it means is that the people who have the greatest contact and the greatest knowledge with the patrons, for example, the gaming staff who see them on a regular basis, are trained in responsible gambling and are expected to take responsibility for those areas. Therefore, they have some chance, we don't say it's perfect, but they have some chance of identifying somebody playing for an extended period of time without a break. They can pick up observable behaviours. And with the benefit of the rapport that they develop with patrons, they can help them via interactions early on in the process. And Mr. Toliafoa talked about the fact that doing that starts to build good habits. So hopefully that process can pick up some people early, help them to develop good habits, and it never gets to the point where those people ever have to have an interaction on the cusp of them experiencing significant gambling harm of the kind that we heard from witnesses A and B and C at the beginning of this inquiry. That's the first aspect. The second aspect is obviously the independent responsible gaming department headed by Mr. Toliafoa. I'm at paragraph 70 now. We emphasise that they're independent of the operational side of the business. Mr. Toliafoa is, his team are. I think it was Mr. Hogg who gave this evidence. If there is a, not a clash, but if there is a tension between their decisions and those of, for example, the gaming team, Mr. Hogg said yes, the responsible gaming team overrules. Thirdly, we have data. There's a manager of gambling risk identification who's responsible for this, responsible for developing other ways of using it. That includes, for example, the time play management system, which is based on carded data. The point is different layers that might catch different people in different ways, and that we make that point, or we emphasise that point, to emphasise that to look at the adequacy of this, the effectiveness of the system, the adequacy of it, the resourcing issues, that whole system should be looked at, not specific parts. Carded play, I think what Mr. Horton said correctly states our position with respect, that there is an acceptance that carded play, mandatory carded play, is valuable and useful, but also a suggestion that it could and should be expanded gambling industry-wide, if I can put it that way. And I think, Mr. Goddison, you made the point in response to Mr. Horton that, yes, that's the reason for that is that one might have a situation where somebody who goes into a casino and has some difficulty, for example, with their gambling, which is based on carded play, might go somewhere else. They might go to the local RSL or the local pub. So expanding carded play gambling industry wide obviously allows for the possibility, allows for the fact that data obtained or something that occurs as a result of carded play in one area is mirrored across the industry. People can't avoid the restrictions based on carded play in one place by going somewhere else.
Yes, I must have, it wasn't clear whether the recent New South Wales proposed amendment is to be mirrored in legislation relating, for example, to clubs and like institutions, but he may have some knowledge of that.
I'm sorry. I don't believe that we know that from our perspective, but it's certainly something that that from the Star's perspective would be.
It would be the optimum, wouldn't it?
Correct. Yes, quite so. That's a good way to put it with respect. It also means that if one goes further, the cards provide data. Data across all of the industries is more valuable. Data from the casino play is valuable. Data from somebody's play, a person's play across all, the casino and the club and the RSL is more valuable in terms of developing patterns and being able to being able to usefully assess that person's gambling patterns. Preset limits for EGMs, Mr. Horton dealt with, and I think again with respect expressed our position well. Self-exclusion, the same thing. Your Honour, sorry, Mr. Goddison, you heard that there are ways in which a person can self-exclude from outside the casino at the moment through a third party, such as Relationships Australia. An online exclusion process we accept would be another useful addition to that. Facial recognition, it's being developed at the Star, Your Honour. Mr. Goddison, you heard the evidence of Mr. Hogg as to the reasons why there's been some time taken, particularly solely relating to COVID, I think is the way he put it. Yes. So that will be at the Gold Coast. It's being developed at the Gold Coast, and it will be coming in at the Gold Coast, and it will be at the new Brisbane Casino when that opens.
I think the Sydney experience was it 8 to 10 times?
8 to 10 times
increase in recognition efficiency.
Yes, yes. So no denying its effect. Mr. Goddison, those were the things we wanted to emphasise orally. We're grateful for the opportunity to do so.
Thank you, Mr. Beecham. Mr. Horton.
Just one point. It's rightly mentioned that in our submissions we say until very recent times, the AML was seriously deficient. The test of the timing, we say, is in the 5 case studies. So one can see what's actually happening in the AML program, not just what's formally happening. And for example, we say that on the 25th of March 2021, so this is 3 years after the KPMG review, person 1 presents with cash from a Chemist Warehouse plastic bag. They're examples, if you like, of how the AML system is being implemented. And as at March 2021, an event happens, which I think on any view should have triggered, again, red flag warning bells. And it seems not to have, of course, because it's not until later that the withdrawal of license is issued. So they're a real test of when this thing becomes not seriously deficient. And by recent times, we mean more recently than March 2021, if at all, because these problems persist, of course, on those concrete facts. That's the test of those.
Thank you.
There are submissions in reply.
Thank you. Well, I think that concludes the hearing in relation to the Part A matters, subject, I think, to reservations in written submissions as to certain areas where further submissions might wish to be made, and I expect that could comfortably be done in writing in any way.
Yes.
So I don't imagine there will be a further public hearing. I take the opportunity to thank all, including counsel, instructing solicitors, and those who assisted them in allowing the inquiry to deal efficiently and effectively with the matters that have been considered. And I think, well, I will adjourn generally the matter now.
Thank you.
Adjourn the hearing.
All rise. This inquiry stands adjourned.